All right, greetings again, and here we are with Lesson 22. Now, as we finished up with Lesson 21, I left you with an assignment, and that was to read Williams versus Florida and see whether or not you could make heads or tails of that case, then write to me, tell me what your opinion was. Now it's time to get into the nitty-gritty of actually picking the jury, and this is where the fun of the courtroom begins. Because unless you're having fun in the courtroom, it isn't worth going in there. And you know, most of you have always had this feeling of, I'll go through death and hell and through fog and rain and snow and Normandy and anything I have to do to stay out of that courtroom. But now what we're trying to do is to get people to go into that courtroom and have a little fun for a change. And when you pick the jury, it really is probably the most fun you're going to have of the whole day, because when that very same jury comes back with the guilty verdict, it is the biggest letdown that you can have. And you must go into the courtroom knowing and understanding that you are going to lose that day. And so when you look over here at the prospective jury panel and say, there are the people who are going to condemn me for doing what it is I'm doing. Those slaves, those Joe Sixpacks over there, are going to say, well, I've got a license and this guy's got to have a license. I have to pay taxes, so they have to pay taxes. Or he has to pay taxes. And so when that happens to you, and remembering this at the end of the day is going to occur, when you're looking at them bright and shiny in the morning, this is where you better have some fun, because at the end of the day, it isn't going to be fun. So when I go in to pick a jury, I recognize that my government has determined for me that this must be expensive and costly for me. After all, I'm demanding rights, and I'm demanding a jury trial. And I'm in that courtroom there upsetting what in the normal run-of-the-mill course of events in the traffic court is a very profitable operation. So the way I figured it was, if my government can determine the most expensive, costly, time-consuming format that they can devise to take up my time, make me lose time from work, to cost me more money than the $40 is worth. The way I figured it, I've got to figure out the most time-consuming, the most expensive way possible to cost that traffic court more money than they're ever going to in a million years, well, I shouldn't say a million, but in any reasonable length of time ever collect from me. So here's what they do to you, now here's what we're going to do to them. Number one, the policeman gives you a ticket, they want a $40 fine, you can walk up to the counter, plead guilty, have the ticket signed, be out, stand in line, pay the $40 plus the $11.50 court costs, and be out of the court in less than an hour. It's designed that way. And if you're clever at it, you can even mail it in and probably not even make an appearance. And if you have to make an appearance, sometimes you can just go to the clerk, or you can go to the court, run outside, get in line, and be in and out in 10 or 15 minutes. It's designed to steal your money that fast. Now, if you want to plead not guilty, you'll have to hire a lawyer, because remember, the lawyers have the courtrooms tied up in their own private union, and that'll cost you $600. Then it'll take you at least a day off of work and probably another day off of work to go to the lawyer and make up your story for him to go in and argue for you, and the plea bargaining and the negotiations and all of this. And so to plead not guilty will cost you $700 or $800. To plead guilty will cost you $40, so therefore your common sense tells you that to pay $40 is the way to do it. Now, isn't that the way it always worked? So what I did was I devised a strategy whereby we could reverse that, and when we go into the courtroom, we don't understand the charges, we're not going to plead at all, let alone plead not guilty, we're going to file dozens of motions on the court, we're going to spend a couple $100 doing so, because we're going to lose a couple, 3 days off of work. And I figured that if my government had plenty of time to spend on a case, I had more time. If my government will spend 1 day on a case, I'm willing to spend 2 days. If my government's willing to spend 2 days, I'm willing to spend 4 days. If my government would spend 4 days, I'd spend 8 or 10. I've made up my mind, and you must do the same, that it doesn't make any difference whether you're going to be in that courtroom for 1 day or 1 week or 1 month. We will be there until we win. Because when that traffic ticket was issued, remember way back at lesson 2, we have already decided and we've already qualified this case for the Supreme Court in Washington. And when you walk into the court, they're going to ask you, are you ready to move forward? And the answer is typically, no, I'm not ready to move forward. I have more motions to file, or you've denied me my motions, or the court doesn't have jurisdiction, or whatever it's going to be. And those are administrative and procedural matters, and I'm going to take those up as soon as we start into the prosecutor's half of the case. But for this moment in time, that leads up, and those are administrative and procedural matters, and we'll take about a half hour or 45 minutes going through administrative and procedural matters, and they'll have to send the jury out while we're going through this. But there comes that magic moment when the judge says, we're going forward with or without you. Did you want to get on the train, Mr. Gordon, or not? Oh, okay. Don't run off and leave me. The jury comes back in, and when the jury comes in and sits down, we begin the process which is called voir dire. That's probably a French or a Latin word that means we're going to select a jury. And we have to speak in Latin or French or whatever it is so that you can't understand what's going on in the courtroom. It's like going to a doctor, you see. You go into the doctor's office, and first of all, when he writes the prescription out, he writes it in Latin so that you can't understand it. And just in case you can understand Latin, he writes it in such handwriting that no man on earth can understand it, let alone a pharmacist. And so when you get to the drugstore, the druggist says, well, what's wrong with you? I got a cold. Oh, I know just what the doctor's telling me here. And so then he gives you some dihydrostreptomycin or some penicillin or something like that. Well, the courts run exactly the same way. In fact, I'm convinced that half the time the judges don't even know what they're saying when they're using those words. Because I noticed that when I went and looked up those words and I came back into the courtroom and I used terms like right sua sponte, this one judge said, well, I've already given you your right sua sponte. And the word sua sponte is right now, immediately, without any delay. Now, how can you give me my rights without any delay until the right becomes known and it's necessary? See, the purpose of that, remember, was for the judge to tell you in a step-by-step sequence of events, you know, when your rights became due, when they became available, when you needed to use them. Yeah. So that tipped me off right away. I don't think those judges understand Latin either. And so I don't think you need to be too concerned about Latin. Let's just keep it in everyday garden variety English so that when you're dealing with the jury, and in some cases you'll use some street language, and after all, those people are off of the street, and they're typically Joe Six-Packs, and they all have driver's license, registered cars, and insured, and they're all in maritime contracts. Now the jury sits over here, and the judge is probably going to administer an oath to them. And they're going to, this is your first oath that he gives the jury, and they agree, under penalties of perjury typically, that they're going to answer all of your questions pursuant to their qualifications as a juror. The only thing you can ask them questions about is their qualification. But that doesn't mean that by the time we get finished with that jury, we're not going to know whether or not they're homosexuals, whether or not they're Catholics, Protestants, or Jews, whether or not they vote Republican or Democratic, or whether or not they voted in the last election, where they went to school. I'll know everything I want to know about anybody. And I've got 84 questions here that I have devised and gone through. I think there's 84. So take your 84 lessons, that's your voir dire. It says right here at the top of the page, Lesson 10, the jury selection. Okay? Well, we're going to change that. And when you get this, it's going to say Lesson 22, the jury selection. And it isn't that you're limited to these 84 questions. The only reason that there's only 84 questions here is because I couldn't figure out how to make 168. And so I'm going to leave that to you. And this thing of jury selection now, pursuant to the rules of this state, the judge is going to hustle you to get you through. Remember Argersinger versus Hamlin. You know it's rush, rush, rush. Remember how the Supreme Court laid that out for us? Okay, so our first duty then is to slow the proceedings down, because I don't want to be rushed to judgment. And every time the judge tries to rush you through something, or to hurry you, or to hustle you up, that's the time. Whenever that happens to me, I always go, oh, wait a minute. I'm not sure I understand what's happening here. I'm still asking some questions to determine whether or not that juror is qualified, whether that juror is neutral, whether that juror is going to render a verdict based upon neutrality. And by yelling at me and trying to hustle me, I don't think I'm going to get the right answers, and I'm not sure whether or not I can determine whether or not this juror is going to be neutral, Judge. So would you please be patient with me, because I'm here acting impropria persona, and I'm just not from law school, and I'm not too smart. Now the judge is going to come down, hustle, hustle. Now remember who has to be in control here. Sometimes I've had judges say, well, that'll end the voir dire. Oh, excuse me, you're going to pick the jury for me. Is that the way you're going to do that? Remember, your whole purpose here is to create reversible error. Best thing in the world can happen is when the judge says, we're not going to let you ask any more questions. Or in the case of one judge that I saw one time, actually limited the defendant to 5 minutes. Okay, Judge, I'll do the best I can. And so you get through about 8 questions. Well, your 5 minutes is up. Oh, that's all the time I get to pick a juror? But I haven't asked any of the really pertinent questions as to whether he knows me and whether or not he knows my family and whether or not this juror over here is really neutral. I don't know if that juror is one of my peers. Well, I'm sorry. This happened to be a guy named, we'll call him Jones. And I'm sorry, Mr. Jones. The court's rule is 5 minutes. And now, Mr. Prosecutor, you may go ahead. When it was all said and done, there's reversible error of him by itself. But you have to be clever enough to create it. If you deliberately stall, and it's obvious that you're just stalling for time and wasting the court's time, they're going to pick right up on that, and out you go. And the judge can do that. Okay? But the judge can't limit you in your voir dire so long as you go question after question after question, and so long as the questions are relevant and whether they're pertinent to determine the jury's qualification. Now, you're looking for prejudice in the jury. So let's say you got a typical fellow over there, and now you're going to have, in this state, and you'll have to check your own rules, but you have 3 preemptory challenges. That means you can disqualify 3 jurors on a 6-man jury without any cause at all. You can challenge every juror for cause, and so the key is to disqualify 13 jurors out of a panel of 18 so that they can't go to trial. Okay? Your goal is to disqualify 13. You need 10 of them for cause, 3 of them in peremptory challenges. That's 13. Now they've only got 5 jurors left, and by this time it should be 3 or 4 o'clock in the afternoon. And if it takes you less than 4 to 6 hours to pick the jury, you're not doing it right. Now, these are not all of the questions you can ask. In fact, many of these questions are not questions that are proper in every case. And I'm going to go through a bunch of questions here that you can use in some cases, and depending upon the particular case that you're doing, you'll have to devise some questions. So let's think of a question. This was really a good one. A fella, I got to tell you this story because it's just knocked socks right off. We had a student here, and he's an older fellow. And some policeman accused him of not stopping at a stop sign at a railroad crossing. And they took him to court. They agreed that if he would pay $16 plus court costs, or it could have been $4.50 plus the court costs to make it $16, that they would be happy as clams at high tide. And you know, this fellow said that any case that's important enough for my government to prosecute is important enough for me to defend. And so, as it turned out, he disqualified 12 jurors. He was one short of knocking the panel out. But he came up with some real nifty questions, and I'm going to pass three of them off to you today and show you how you really lay them away. Anyway, it took all day to do the case. In fact, I think it took 2 days. It took 1 day to pick the jury, and then it took most of the next day to try the case. So there was 2 days, so that's about $2,000 over a $16 parking ticket. And you know what? The jury found him not guilty. And it kind of broke our record. You see, we have 2 students now that have gotten jury verdicts back not guilty. And I've always said, you know, I've never won in front of a jury. I'm still, you know, like the ant, I have high hopes. But this fella actually won. Now watch what he asked. First juror comes up there, and he goes through a few routine questions like, how did you pronounce your first name? Oh, Jones. Debbie Jones. So I say, and you spell that Jones, and so I like to write it down, Debbie Jones. And then I like to draw a line like this right down the middle of my page, and then 2 lines across, so that you have a total of 6 blocks in a 6-man jury. 12 blocks, 2 pages, if you're going to pick out a 12-man jury. So now I got Debbie Jones up here. How did you spell that, Debbie? Jones? Are you married, Debbie? Yes. Do you have any children? Yes. How many do you have, Debbie? 3. 3 children. Well, gee, that sounds like a nice family. You might engage in a little banter and a little chit-chat. Are you a native of Idaho, Debbie? No? Well, where did you come from? Oh, Illinois. Well, that's a nice state. What part of Illinois did you come from? Oh, Decatur. Is that where they build those Caterpillar tractors? You know, I thought that. Did you ever work for Caterpillar? Now, you see, those questions about Caterpillar Tractor Company aren't in here. But when you ask a question and you get a response that will trigger 5 other questions, you can sit here and ask questions about Caterpillar Tractor Company. Did you ever work there? Did your daddy work there? Did your mommy work there? What did they do back there? Where did you go to school? Did you graduate from school? And this just goes on and on. Pretty soon, though, the prosecutor's going to jump up and say, Mr. Gordon is just stalling for time. Why, he's got a list of questions over there, and there's 84 questions on his list, and he's just stalling for time, and he's just wasting the court's judicial economy. Those are the words that they use here. Wasting the court's judicial economy. He'll finish at some point in time. And then it's your turn. And then you rise eloquently. I'm glad he asked that question. And about 15 or 20 or 30 minutes later, you know, one time I had a guy do that, and I preached him a sermon for about 30 minutes about judicial economy and my right to a jury trial and my right to voir dire. And with this book you've got here on juries, when you get to the end of it, you'll be able to talk about voir dire and challenges, jury of your peers. And in the state of Idaho, do you know that you can actually challenge a juror and force him to produce his genealogy for 4 generations and do it by statute? And that's what this fellow John did. He actually demanded that the jury tell him for 4 generations back where they came from. You were born here. Now, you can't ask them if they're a Mormon, you see, because you're asking a question that gets into their personal lives and religion and politics, and their voting habits, you see, are not part of it. And the sex habits are not part of it. Now, what you want to do is find out if this fellow is a Mormon. Okay? How many children do you have? Well, 3 didn't give you a clue, but 12 would have. 12 would have narrowed it down to Catholic or Mormon, wouldn't it? And I'm not saying that, to be derogatory. I'm just sitting here saying, if you're up on a drug charge, the last guy you want on that jury is a Mormon. And the first guy you want on that jury is a long-haired hippie Hell's Angel with a leather motorcycle jacket on. And by the same token, if you're a person who is taking your children out of school and you want to educate them at home, and you've got some moral convictions and your position is, I don't want to send my kids to that government school where they learn how to smoke dope and learn all kinds of filth and depravity, the first guy you want on the jury is a Mormon, and the last guy you want on the jury is the Hell's Angel with the motorcycle jacket. Okay? Now, your common sense is going to tell you who you want on there and who you don't. The problem is that the prosecutor is going to knock off the jurors that you want. What he's looking for is the school teacher from the 3rd grade who's 62 years old or 71 and retired, and who's the little Miss Goody Two-Shoes, you see, who would never think of breaking a law or challenging a law, who would never ride the front of the bus, who would always ride the back of the bus, who's got the mentality of a slave, and who is a slave, and has worked in the slave system all of her life, and that's the kind of a juror he wants on there, and that's the kind of a juror that you want off of there. Okay? Now, your common sense will tell you that. Now, how do you accomplish this? Well, when you go in and you watch the average guy, the government and the judge will have the jury picked for you in about 45 minutes to an hour, and you're sitting there going, what happened? And there's these 6 government workers on there. One of the first problems that we have in Boise, Idaho is that since this is the capital of the state, we have an overabundance of government workers. So if you can devise a stratagem to eliminate the government worker, and this is what you'll do at the end of this voir dire when you refuse to accept the jury as it's impaneled because it's not a jury of your peers, well then, terrific. But meanwhile, on juror by juror, you see the length of time that I took to answer those questions? Let's run over that again, because that's about the pace that you want to go through. And you'll start here on the 2nd juror. Well, hi there. What did you say your name was? Oh, Don Johnson? Is that spelled Johnsson? Don, are you married? No. How many children do you have, Don? Oh, wait a minute. The guy just said he wasn't married, right? So to ask him how many children he has is kind of dumb. And I've had people take these 84 questions off of here, and just start, they'll walk in and they'll say, okay, now Mr. Gordon said, how do you pronounce your first name? Okay. Are you married? No. How many children do you have? Are you a native of Idaho? Maybe the guy says, no, I don't have any children and I'm from New York. Are you a native of Idaho? No, I'm a high school dropout and I came from New York. Where did you go to school? He said he's a high school dropout. Where did you go to college? Did you go to college? Where? You see, they're like automatons. What they really are saying is, I don't like the government master, and Mr. Gordon, you're such a good master, I want you to be my new master. And I don't want to be your master. What I want you to do is to learn how to think for yourself and to be a leader. When you walk into the courtroom, this is my courtroom, Judge. Thank you very much for coming in to sit in on my case today. I appreciate your time. And now it's time for us to pick the jury. Now, the judge is going to direct the overall flow of events. But as you're going through your questions, remember, they should be slow, deliberate, and they should have meaning, and they should have weight and force. And every question you ask, if the prosecutor objects, for whatever reason, you should be able to stand up and preach at least a 5-minute message as to why that question is necessary and imperative. And there's a good reason for that. Now watch this. You ask the question, how many children do you have? Are you a native of Idaho? Did you finish high school? Objection, Your Honor. These questions are all on the juror's voir dire question and answer sheet. Mr. Gordon knows full well that all of the answers on the questionnaire have already been asked and answered by the juror himself, and he's just wasting the court's time. Remember, at some point in time, he has to shut up. Well, I'm glad that you asked that question, and I'm sure that these questions probably are on this jury selection list. Unfortunately, mine is a photocopy, and my list over here is full of blanks, and I can't really read it. It's so poor a copy. Now, typically here in Boise, that's what we've got. There's one answer. Now, perhaps if you could give me your copy reads clearer than mine, and if I could just trade you copies here, Mr. Prosecutor. About that time, the judge will come in. Wait a minute, Mr. Bailiff, could you get another copy? Mine isn't too clear either, Mr. Gordon. I've actually done that. Now, what if you've got a crystal clear copy, and you can see plainly that the guy has already filled out his jury questionnaire, and it says on there, Hank Snow, and he was born blah, 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 and whatever date it was. Okay, so you go ahead, and then the answer is fairly simple. Well, Your Honor, you know, I don't talk too good. And in order for me to ask questions of a total stranger, I really have trouble talking, you know, to total strangers. And I need to get a little dialogue going with the gentleman before I ask him questions like, do I look like I'm guilty, and do I act like I'm guilty, and you know, so, and I'm really embarrassed to do this, and this is the first time, and I haven't been to law school, and I don't think it's too much to beg the court's indulgence to simply ask a few of these simple questions in order to get the dialogue and the conversation going, so that as we go through these questions, I can get a better feel of how that man relates to me. You know, if I ask somebody how old he is and where he went to school, and I find that he went to school in Idaho, and if he were to tell me that he went to the University of Moscow in the Soviet Union, and that he really hates our Constitution, and I would start to get a bad feeling. But I think that if I could ask these questions, and there's another reason too, you know, it's one thing to look on a piece of paper, Judge, and to see that the man says married, divorced, widowed. But you know, if you ask a man, are you married? And he says, yes, I'm married. Well, the way he answers that question, Your Honor, that tells me that he's not happily married. But if he answers the question, no, I'm sorry, my wife died and I'm a widower, I'll know that he's sad that his wife died and that he was a happily married man the whole time. And if he answers the question, yeah, I'm a widower, my wife died a couple years ago, then I know that he was a miserably married man, and he's really happy that his wife died 2 years ago. And it's the voice inflection, Your Honor, that I really need in order to get a feeling as to whether or not he's prejudiced against me. Now, you'll notice I took about 2 or 3 minutes, and I'm just getting wound up. You know, I've had prosecutors object, and the judge gets so tired of listening to me ramble on about why it is that I needed to do this, that they've actually forgot what the objection was about. That's a fact. And then sometimes they'll sit there, and I've had a judge say, would you repeat your objection? And the prosecutor will sit over there and, well, I didn't write it down, Your Honor. And he can't even remember what his objection was. His objection was that I'm taking too much time and that the information is on the jury list. It only takes about once, maybe twice max for that to happen, and they can figure out that it takes more time for you to rebut his objection than it would be to just shut up and let me ask the 4 questions. Because if I ask the 4 or 5 questions, it would probably take a minute or maybe 2, and if you sit over here and object, it could take 10 or 15. And that's just to get the rebuttal back. I'll tell you what I really love. I just love the prosecutor to sit over here and object, because every time he objects, I'll get up and preach him a sermon for 15 minutes. And that'll break him from sucking eggs, and it'll break him in a hurry. And after all, I've already decided that if it's important enough for my government to prosecute, isn't it important enough to get the best caliber and the best quality jurors that the legal system can provide? I mean, if it takes 2 or 3 days to pick a jury, so what? Aren't we interested in justice? Are we interested in judicial expediency? Not the first time the judge sits there and tells me that, I sit there and ask, well, my goodness, are we interested in judicial expediency and money? Are we going to lower the standards of the court and the system of justice to that of money? We can't afford the defendant justice because it takes too long and it costs too much. Is that what the court's telling me? Now, do you see what we're doing? Now, it'll take 2 or 3 jury selections for you to really get good at it. But the very first jury selection you go to, you should always have counsel there to help you. And your friend will come in and he'll think of questions to ask this person as you're going along. And the reason for asking these trite little questions to kind of get the feeling is that when this fellow tells you that he's from California, and you get a feeling, you know, he's from out of state, and that he's an FBI agent, he's a government agent, and he's probably licensed and totally juristic, you probably don't want him on the jury, see? So these little trite questions give me a feeling for this fellow, because later on I'm going to preach him a sermon on my closing argument, am I not? And tell him why it is I don't have a driver's license, and I kind of would like to have the type people on there that I can sell something to. And you've got about 30 minutes in your closing statement to sell this fellow your position. All right, now, if you'll notice here, I've got Debbie Jones, and I've got yes, and 3 children, and no, and I'm from Decatur, Illinois, and so on down the line. As you go through this list of questions, and you find that here's a real nifty one, I've got to tell you what John did over there. You've gotten the banter going, and now this person is sitting over there, you know, knowing now by about the 15th question that you're serious. Because the prosecutor, he'll ask about 5 questions, and that's it, and he'll pass for cause. You get up to about 15, and then you start to get a little stronger. Do I look like I'm guilty? Well, now, a total stranger over here feels a little funny saying, yeah, you look like you're guilty to me. Now, if you didn't want to serve on a jury, that's the best answer you could give. Yeah, God, you know, you just really look guilty to me. The judge will perk right up, you know, and then they'll usually come down on jurors that give answers like that, and they'll give them a patriotic speech about how it's your duty to serve on the jury, and that to use excuses like that to get out of serving on the jury, you know, is unpatriotic and bad, wicked, terrible, and awful. And the prosecutor and the judge, they want the dumbest, most ignorant. If they could, they would take all 16-year-old schoolgirls chewing bubblegum and giggling in their hands. Yeah, that's what they really want over there. People that can be totally manipulated and controlled, who have no knowledge, no ability, no talent. You know, they're just, what are you here for? Now, you listen carefully, children, while I give you these jury instructions, while I tell you what it is you're going to do, what your duty is. That's what they want. Well, since that's what my government wants, what kind of people do I want over there? I want some grizzled old farmer that's about 75 years old and has had it with his government right up to here. That's the kind of guy I want. I want a truck driver over there that has to go through a port of entry 3 times a day and go through the red tape and the BS that the government puts on him day after day. That's the kind of guy I want. And, of course, that's the kind of guy they're going to try to bump. Just like I'm going to try to bump the 16-year-old schoolgirl. So when you take a look at that jury panel coming in there, you remember now, is if you're going to pick and get 1 or 2 people on that jury that might go in there and hang it, then you're going to have to search a little bit for that kind of person. And so you've only got 3 preemptory challenges, and that's like 3 votes, and you don't want to throw those 3 votes away. If you can disqualify a person who says, yeah, you look like you're guilty to me. Well, I challenge for cause, Your Honor. I don't think there's any point in going forward with any further questioning of this juror. The mere fact that I look guilty before he's ever looked or heard at any of the evidence or heard any of the facts of the case shows an extreme bias and prejudice against the defendant on his part. See your little speech. The judge will then, Mr. Johnson will excuse you at this time. You will please report to the jury commissioner for any further jury duty that you may have tomorrow. Okay? And there you've bumped 1 for cause. Okay? And it hasn't cost you a vote. So now you come up to the 3rd guy on the list. And you go down the list over here, and you go through the same banter of questions. And you say, since I've been taken to jail, where there's smoke, there's fire. Wouldn't you agree? Yeah, I think I would agree. A man that's taken to jail must have done something. Isn't that logical? Yeah. Well, Your Honor, I don't think there's any reason to go any further with this particular person. It's obvious that since I have been arrested, and he believes that anybody who's arrested must have done something, therefore it's going to be extremely difficult, if not totally impossible, for this juror to sit in this case. You see what you did to him? And this fellow John that I'm telling you, Gordon, just because you were arrested, that doesn't mean a thing to me. That's what you're forcing that man to say. The easy answer is yes. And so, instead of asking a positive question, you ask a negative question. You ask the question, you could ask the question both ways. Now, just because a man has been arrested and taken to jail certainly doesn't mean that he's guilty now, does it? Oh, no. So, you want to bump this juror, right? So, you ask the question in this context. Since I've been arrested and taken to jail, where there's smoke, there's got to be fire. Wouldn't you agree? Yeah. Human nature tends to want to agree, and every salesman knows that when he goes through a list of questions, he wants to elicit from the prospective customer a series of positive answers. Don't you agree that sleep is extremely important? Well, yes. And don't you agree that family life is one of the basic founding bedrocks of our society? Oh, yes. And don't you agree that motherhood and apple pie are just absolute requisites to the American system and way of justice and law and order? Yeah. See? Now the magic question is the closing question. Well, wouldn't you agree that a waterbed then is just practically something you can't live without? Yeah. And it just so happens that here in my catalog I have 3 of these waterbeds for you to choose from. And that's what every salesman will do to you. I don't care whether he's selling insurance or waterbeds or whatever it is. He knows he has to get some positive responses from you in order to get your mind to thinking in yes, 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 and wouldn't you like to sign this sales contract, and wouldn't you like to buy 3 of these, and wouldn't you like, yes, 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 yes. Okay, well, a little psychology on the jury does the same thing. And all of a sudden, about the 3rd or 4th one, this particular judge just come unglued, and he preached the jury sermon and said, if you people all want to be disqualified, then you just keep answering the question that way, and you'll all be disqualified. That was the report I got back. The judge just came unglued. Right? Now, how many questions can you ask like that? Well, you should come up yourself, depending on the type of case that you're talking about. Now, obviously, if you haven't been arrested, well, then you can't ask the question, since I've been arrested, then it's obvious I must have done something. But let's say that, for the sake of argument, that you have been arrested. Did you see that nifty question? Because almost everybody believes that if you've been arrested, you must have done something. And you see the trick question? He must have done something. And the guy's going to say, well, yeah, why else would the policeman arrest you? But as the moment you got that yes answer out of him, you disqualified him. But see, you can only do that once or twice. Or in the case of a judge that doesn't jump up and down rapidly enough, 4. Well, once John got rid of 4 of them, well, then the next question was, do you have a driver's license? Yes. And do you drive? Yes. How much do you drive? Well, about 10,000 miles a year. And you go through a little driving scenario of questions. Oh, maybe 5, 6, 8 kind of innocuous questions. And as you're looking down, you ask this question like this. Well, then, a person who doesn't have a driver's license is obviously breaking the law. Yeah, I'd agree with that. And the person that doesn't have registration on his car is obviously breaking the law. Yeah, I agree with that. Now you see what you've done? You're being charged here with no driver's license, right? You're charged with no registration, and here's a guy that says, well, obviously you're guilty. I don't need to listen to any facts or extenuating circumstances or intent. Well, I know you're guilty. You just see what you've done to him? There's your second tricky question. All right? And I think I've got that tricky question down here somewhere. Didn't I put that in here? Yeah, do I look like I'm guilty? Now, if you ask a guy, do I look like I'm guilty? You see? Or if you ask trick questions, one after another, they're going to shut you down. I'm telling you, you can come up with 20 questions like that, I'm sure. But you see, they're going to call you on the trick question. So that type of question that elicits an answer that prejudices the jury, or that particular juror, you only ask those once every 10 or 15 questions. As you're going through, and we're assuming we have a traffic case over here, and you haven't been arrested and taken to jail. Maybe it's speeding, see? Then it's up to you to sit there, and use your brain a little bit and sit down with a couple, 3 friends and say, what kind of questions should we be asking those jurors? Have you ever gotten a ticket? And this is where your old prosecutor comes in, He asks questions like these. Well, now, I'd like to ask all of you jurors 4 or 5 questions. Do all of you drive? Yes, we all drive. And I'm sure that all of you have driver's licenses now, don't you? Yes. And all of you are aware that we have laws to protect us and to regulate our society for the good and the benefit. See the way he goes on with a little speech here and tells them that the law is for their benefit and the good and the righteousness of society, and all of you obey it and recognize that we have to have those laws now, don't we? Yes, we all have to have those laws. And that even though it may be distasteful and sometimes I'll get a ticket and sometimes you'll get a ticket, but we have to come in and pay our tickets. And while it may be distasteful, we have to do that now. Don't you agree? Yeah. And so here the prosecutor is going to totally prejudice the jury against anybody who would walk into a courtroom and even plead not guilty to not having a driver's license in possession or not having a driver's license at all. See, he's done that right off the bat. And the average guy doesn't even recognize that he's just been brainwashed. He's just been told that, well, we got these traffic laws and I don't like them. But all of the jurors are licensed. What do you think would happen if you got a real honest jury of your peers in there? And let's say that the prosecutor was going through that, and I'm sitting there. See, I'm a prospective juror, and I'm just kind of sitting there. Mm-hmm. But I'm supposed to go like this, right? Because you see, if the prosecutor is looking at 6 jurors, and he asks a question like, now all of us have to have driver's licenses, don't we? And 5 jurors are going, and Gordon is going, I've just bumped myself from the jury and condemned you because the one juror who's really probably a jury of your peers. See, I could sit here and say, well, I don't know if that person is supposed to have a driver's license or not. Is he a Garrett driver? Was he driving for profit or gain on the highways? Was he using the highway in an extraordinary use? See, I'm probably the only guy on there that could be an impartial juror that knows and understands the law. You know, if I had some guy in there who didn't have a driver's license and he was out using my road for profit or gain, you know, on the Roman circuses, down the tubes. But now you come along and you're just using the road because it's yours and you think you've got a right to use it. So I'll tell you, when you get out there on that jury panel, or when I get on there and the prosecutor's asking me questions, now, we all have to have driver's licenses now, don't we? I haven't lied to anybody. Let's just listen to this for a moment. We all have, there's a generalized question, we all have to have driver's licenses, don't we? You bet, we all do. Because all is a group. And out of the group, there's 50. And out of the group of 50, I believe that 48 of them probably need driver's licenses. Probably all 50 need driver's licenses. If for some reason there's one or two in there that don't need driver's licenses, that's why we're here today to listen to the case. And that fellow's going to tell us why he doesn't need his. I'm not sitting there. And don't ever let those prosecutors and judges do that. They try to make the jury feel like, now you've taken an oath and sworn to uphold the law. And your duty as a juror is to follow the instructions of the court. And the first time you say, to hell I do, off you go, and the only honest juror in there is off the jury panel. And they'll ask questions like this of the jury. Have you ever had a bad experience with a police officer over a traffic ticket? And so every 71-year-old school teacher who never rode or drove a car and who had a driver's license maybe when she was 18, she's sitting there going, no. You know, and there's just lots of people out there that haven't had too much problem. You know, if you're a good slave and you ride the back of the bus, you won't have a problem. It's only the guy that rides the front of the bus that's got trouble. And so, and here's the jury panel, you know, there's all 18 of them over there on some of these general questions, depending upon how they proceed, of course. And I've actually had jurors sit over there and say, yeah, I've had some bad experiences. I think these cops are just using the law to gouge us and to steal our money, and I don't think I could render a fair verdict in this case. He's the only guy there that could render a fair verdict. But nobody's ever told him about jury nullification. Nobody ever told him about jury lawlessness. Nobody ever said, well, why don't you sit there and listen? Just because you had a bad experience with a policeman doesn't mean I have to sit there. I've had lots of bad experiences with policemen, but I've had a lot of good experiences with policemen. So when they ask the question, have you ever had any bad experiences with a policeman? I just look around, you know. And don't you agree that the laws are there for the benefit of society? Oh, you bet. Sure. I think so. And that whether we like the laws or not, we have to obey them? Yeah, I think laws ought to be obeyed. You bet. Mm-hmm. The only thing I don't know about this particular law, but maybe it should be obeyed too. I don't know. After all, I don't know anything about this case, and that's the qualification you want in a juror. Let's suppose that you're the juror and you're being voir-dired by the prosecutor. Have you ever had any bad experiences with a police officer? Oh, I don't think I've had any bad experiences with a police officer that would jeopardize my sitting here on the jury. Well, have you ever gotten a ticket before? Yes. Oh, yeah. How many tickets have you got? Oh, I don't know. I've been driving for a lot of years, and I've gotten several. I know that. But if you ask me exactly how many, gee, I don't know. And boy, if you don't think that's the truth. See, it's all in the way, it's in your outlook, in your attitude in life. You know, you can sit there, yeah, I've gotten probably 20 or 30 or 40, I don't even know how many. And then you're surly and you're nasty, you know. I hate prosecutors. I've had it with you prosecutors. See, what you got to do is you got to get your frame of mind straightened out to where that prosecutor is just a nice guy. And, gee, hi, Joe. Gosh, good to see you here today. Only you can't know the guy, see? And they'll ask you, well, do you know the prosecutor or the defendant? I probably wouldn't even recognize or know my own brother if he was sitting over there. Only if it was my brother, I'd probably have to fess up and say, yeah, the defendant's my brother, so I don't think I can sit on this case. See, that's too obvious. But I don't have to sit here and say, yeah, I recognize him. Why, he's the salesman down there at Thriftway Lumber Company, and boy, I really like him because I left a $5 bill on the counter one day, and he gave it back to me, and he's honest, and I think I ought to, you know. You say that, and right away the prosecutor wants to bump you, see? Or if it's the other way around, yeah, I know that guy down there, he stole $5 from you. Well, then he wants to bump you. What you want to do is to get on that jury so that you can educate those other 5 or 11 jurors to jury nullification, because the overall goal that we're after is to reinstitute our common law from coast to coast and border to border. And to do that, we're going to have to get our Republican form of government back, and we're going to have to get our juries back. It's just that simple. And so in your little local area, you'll be amazed at what you can do when you get into that jury room. And I've talked to fellows that have been in there, and, well, the judge told us that we had to rule according to the law, and they'll pick a jury foreman, and there'll be one knowledgeable fellow in there. And he'll sit in there and tell them about jury nullification and jury lawlessness, and let's take a look at this in the context of you and I, you know.